morning, welcome to the CABE webinar for Wednesday the 17th of February. So today we are looking at administering construction contracts under the JCT Minor Works 2016. So most of you will know already, but I am Jordan and I am the Regional and Student Services Coordinator at CABE, and I will be the moderator for this session. We do like to make these interactive and encourage you to send in any comments or questions. So there are multiple ways you can do this via the questions tab. If you're watching us on YouTube, you can email us or you can tweet us using the hashtag CABECPD. So today your presenter is Michael Gerard. So Michael very kindly presented for us last year and had agreed to come back for us. So he will be presenting the webinar for us today. So Michael was called to the bar in 2016 and since 2013 has been practicing as a solicitor specialising in construction, engineering and contract law. Prior to this, he practiced as a quantity surveyor before specialising in forensic quantity surveying and becoming an accredited expert with the Academy of Experts in the fields of quantum and delay. Michael is also a chartered builder and a panel registered adjudicator with the Royal Institution of British Architects, the Chartered Institute of Arbitrators and Hunt ADR. Michael is the founding partner of Michael Gerard Solicitors, providing legal services on matters including pre-action protocol, party representation and in adjudication proceedings, and ADR including mediation and negotiation, and contract drafting and or review. Clients include principal and specialist contractors, industry professionals, local authorities, developers and employers. Michael's experience includes a range of public and private sector projects from schools, hospitals and housing to military and nuclear installations. He has also been involved in numerous instructions relating to tribunals and case management, as well as in excess of 100 adjudications as adjudicator and party representative. Michael also regularly has articles published in the media and also lectures on various aspects of construction law. So with that, I'm just going to hand over to Michael now and he will take you through his presentation.
Thank you very much for that, Jordan, and good morning, everybody. I'm just going to arrange my screen and hopefully everyone can actually now see the slides that I can now see on my screen. This is, as Jordan said, is a live webinar presentation as brought to you by the Chartered Association of Building Engineers, and I'm much appreciated of being invited to actually talk to you once again. The talk today is on the administering of construction contracts under the JCT Minor Works 2016. There are three forms under the Minor Works. The one that I will be going through today is the JCT Minor Works. There's also the JCT Minor Works with Contractors Design, and there's also the JCT Minor Works for subcontracts with subcontractors design. That is the use where the contractor is under the minor works with the contractor's design with the head employer, and then with subcontractors that is used. Where do we use the minor works? Well, as the name implies, it is small works, but it is not necessarily guided on value. It is works which are of a fairly basic construction and works of a very simple nature. There is no guidance to the value of the work, and it should be the nature of the contract as opposed to the value that should be the deciding factor on which form of contract to use. There are other forms of contracts outside the minor works, like the intermediate form of contract and the JCT standards, but they are for larger projects and more complex projects. The JCT Minor Works is a traditional lump sum contract, and it's based on drawings and or specification and or work schedules. And the minor works, the administration under that is fairly straightforward with very few procedural rules. What exactly is in the minor works? Well, we have the agreement, we have the recitals, then follows the articles, then the contract particulars. The attestation is where you sign it either underhand or as a deed. The conditions of contract are sections 1 to 7. Then you have the schedules. And now I'm going to go through a little bit more detail on those indexes. The agreement, that simply identifies who the employer is and who the contractor is. And of course, it needs to be dated. The recitals will identify the works. So it's a brief description of the works and the location of the project. And it will also have a list of the contract documents. Again, very, very important. Very simple, very important to get this absolutely right. The articles is essentially a memorandum of the agreement, and it will identify the contract sum, and it will also identify who the contract administrator is. And it's very important to have a contract administrator identified as an individual, not as a company. It can be an external individual, i.e. a consultant, or it can be in-house. But be very careful is where you actually name an external contract administrator. You cannot then replace that external contract administrator halfway through the contract with an in-house. The contract particulars, it will show the notification and negotiation of disputes. Is arbitration to apply? That must be filled out, and it must be stated Article 7 and of the Schedules 1 applies. You also need to have the works commencement date, the date for completion. So between the works commencement date and the date for completion, that will give you your period. It will identify what the liquidated damages are. It will identify the rectification period. The default period of the rectification under the minor works is 3 months, but of course that can be extended, and it's quite usual to be extended to 6, even to 12 months. Interim payments, the default period is every month. There's retention under minor works, different rates of retention pre and post contract of 5% and 2.5%. Then you have your final account where the contractor supplies the documentation for the computation of the amount to be certified, and the default period for the contractor to supply that information is 3 months from the practical completion. And under the contract particulars, you will also identify, or you may identify, who the adjudicator is and the arbitrator, or you may just identify the nominating body. If you don't, then there is a default provision under the minor works. The attestation, as I said a little bit earlier, is that it's either a simple executed contract, which is basically signed by each party, or it's a deed, which is under seal. The difference between a simple contract and executing a contract under seal is the limitation period. It's 6 years from the date the cause of action accrued. Under a simple contract and under a deed, it's 12 years. Entering into a contract, be very, very careful in relation to what you agree and how you agree it, the number of times that clients have referred to me to say that they're actually, this is what they've agreed. You look into it a little bit more, and in fact, it's something completely different to what they actually thought that actually had agreed. My recommendation here is, before you even step foot on the site or let a contractor on site, is execute the contract. Section 2 of the Minor Works is all about carrying out the works. Clause 2.4 is a correction of inconsistencies. This is where there's any inconsistencies between any of the numbered documents under the contract, and if there are inconsistencies, the contractor must notify the contract administrator, and the contract administrator then issues instructions, which then become a variation under the contract. Clause 2.7 is the extension of time. It's critical the contractor notifies the contract administrator, and then once notified, the contract administrator then considers the notice, and will only give an extension of time if any delay is, let's go back to that, excuse me. That's me, my big fingers accidentally pushing a wrong button. I do apologise for that. Extension of time. The one thing about the extension of time and the application by the contractor, and when the contract administrator is considering the extension of time, it is crucial that any event that's actually claimed for, and that's a little e, is it must have delayed the date for completion. There may be an event that's in the middle of the progress of the works that may have caused a delay at that time, but if the delay did not cause a delay to the date of completion, then there cannot be an extension of time. The contract administrator is under an obligation to award an extension of time as may be reasonable, and should the contract administrator give reasons, the Minor Works remain silent on that, but it is good practice to give reasons. Liquidated damages, the clause is 2.8, and this must be filled in the contract particulars. The test now, it used to be, it must be a genuine pre-estimate of the likely losses, but the test, I say the new test, it's been about now for about 6 or 7 years, is the liquidated damages unconscionable or extravagant? One of the other things that I find a lot of employers do is that they state damages as nil, or they not stated at all. This is bad practice, because if the liquidated damages is not stated from the outset, then the employer must prove that they actually incurred a loss. Clause 2.9, practical completion. Practical completion is achieved upon the opinion of the contract administrator, and great care must be taken in certifying practical completion, because a lot of things change. For example, the contract administrator's powers will come to an end. There is a start of the limitation period. The rectification period also starts. The default position of that is 3 months. There is a release of 1/2 of the retention, and the employer takes over the building and is responsible for insurances. Clause 2.10 is the defects clause. Whatever the rectification period is, at the end of the rectification period, it is the CA has got 14 days to inform the contractor of any defects. And under clause 2.11, once the defects are rectified, then the CA, in his or her opinion, will issue a certificate of making good. Clause 3.2, and this is now control of the works. Clause 3.2 is the person in charge, and a person in charge must be competent, of course, and deemed to be authorized to give out instructions. Clause 3.3, subcontracting. It requires the contract administrator's consent, although again, in my experience, this very rarely happens. And the subcontractor should be engaged using the JCT short form of subcontract. Clause 3.4 is the administrator's instructions, and once an instruction is issued, the contractor is obliged to comply forthwith. Written or oral, but if oral, there is no effect until the contract administrator confirms that oral instruction in writing. Clause 3.5 is non-compliance with the instructions. So what happens if a contractor doesn't comply with a written instruction from the contract administrator? Well, the contract administrator will give a 7-day notice the contractor to comply. And if the contractor doesn't comply within that 7 days, the employer may then employ a third party to carry out that work, and the contractor is liable for the costs. Clause 3.6 is the variation clause, and any changes to the works is referred to as a variation and falls under clause 3.6. 3.6 also requires the parties to use their best endeavours to agree a price before the work is carried out. And if a price cannot be agreed, then it's valued on a fair and reasonable basis using A, any relevant prices in the price schedules, and or B, valuation to include any direct loss and expense due to the regular progress of the works being affected by compliance with the instruction. What that is saying in relation to direct loss and expense is that there's not, unlike the JCT intermediate form of contract and the standard form of contract, there is not an actual loss and expense clause. So the variations also need to actually consider any loss and expense and be priced and valued under clause 3.6. Clause 3.7 is provisional sums, and it's the contract administrator must issue instructions as to the expenditure of those provisional sums. It's usually good practice for the contract administrator virtually on day one to omit the provisional sums and then subsequently issue any instructions in relation to the expenditure of those sums. Clause 3.8 is any individual can be excluded from the site. Section 4, payments. The clause 4.3 is the interim payments, this is where it actually sets out exactly how the payment mechanism works. The due date is 7 days after the relevant valuation period And as I said before, under the minor works, it's a monthly valuation. The contract administrator is to issue payment certificates, and that notice must state the sum that the payer considers to have been due at the payment due date in respect of the payment and the basis on which that sum is calculated. And that is also found under the Housing Grants Construction Regeneration Act, section 110A. And that certificate or payment notice, as the Construction Act refers to it, must be issued within 5 days of the due date. Clause 4.4 is the contractor's application and payment notices. Under the JCT Minor Works, the contractor can make an application, but it must comply with section 110B of the Housing Grants and Construction Regeneration Act, as it could also become the payment notice in default. And again, that is also referred back to the Housing Grants Construction Regeneration Act under section 110B. Clause 4.5, a very, very important notice, which is the pay less notice. And that's got to be issued on time. I do have a little table in a couple of slides' time that sets out the actual how the payments actually works and the dates. And clause 4.6 is where the employer fails to pay an amount, interest is due on the sum that's outstanding. I'm not sure how big this sketch is actually showing, but if anybody wants a copy of this, I can very easily email yourselves if you want to get in touch. But it shows that where the end of the relevant period comes to in relation to the valuation, which is under clause 4.3, you can then see, or hopefully you can then see, that within 7 days or 7 days later, that's the due date. Now the due date is the important date, because that sets off all the calculations in relation to the notices and the final dates for payments. You can see under the JCT that the actual final date for payment is 28 days from the due date, whilst the pay less notice under the minor works has got to be issued no less than 5 days. And this is a table that, as opposed to a flow diagram, that actually shows and sets out again the actual periods. Still on payments, clause 4.7, the contractor has a right of suspension. In fact, this right comes from the Housing Grants Construction and Regeneration Act as amended. If there's no payment from the employer by the final date for payment, then the contractor must, in the first instance, give a 7 days notice. Then that's followed by a final notice, at which point the contractor can suspend. Once payment is received, the contractor also has the right to recover all of its reasonable losses and expense as a result of the suspension. So those reasonable losses and expense will include demobilisation of the site and remobilisation of the site. This is another diagram showing the contractor's rights of suspension. And again, I have got this that can be sent to anybody who would like a copy of this. And but essentially, the first, most of the other parts is to do with the payments. And then if you go right almost to the end where you've got the final date for payments, that's if the employer fails to make payments under clause 4.3, that's when the contractor can issue a 7 days notice of its intention to suspend performance, and after 7 days issuing a further notice, and suspension is then of all the works is then carried out. Clause 4.8 is the final certificate and final payment. The contractor is to supply to the contract administrator post practical completion all the documentation reasonably required for the computation of the final payment. Now, in practice, what that I wouldn't say what that means, but what usually happens in practice is that it's the contractor will provide its statement of its final accounts with the supporting documentation. The due date is 28 days after receipt of the final accounts from the contractor, or 28 days post certificate of the making goods, whichever comes later. The payment notice is then to be issued within 5 days of the due date, and again, importantly, the pay less notice is still applicable in relation to the final payment. Termination. This is under section 6. Clause 6.2 is the notices under section 6, and it states that no notice is to be given unreasonably or vexatiously. It's not very easy for me to say that one. It takes effect on receipt of the notice, and also take note under clause 6.2.3, the delivery method. That includes personal delivery and sign for, raw mail sign for. But it's very, very important to also get the delivery method stroke the service absolutely correct, just like getting the notices are correct as well, and your grounds. So termination in relation to any default by the contractor. So this is where the employer has grounds to terminate the employment of the contractor under the contract. Clause 6.4 is defaults by the contractor, and there's 3 categories or 3 grounds that falls under this clause. The first one is where the contractor, without reasonable cause, suspends the works wholly or substantially, or where the contractor fails to carry out the works regularly and diligently. That means that the contractor can still be on site, but if it's not basically performing, it is not carrying out the works regularly and diligently. And the third one is fails to comply with the CDM requirements under clause 3.9. Now, the process of the termination or the default of the contractor is that the contract administrator will issue a notice specifying default, and gives the contractor 7 days to remedy the default. And if the default is not remedied within that 7 days, the employer can then terminate the contractor's employment under the contract. Clause 6.5 is another grounds for termination of the contractor's employment, and that is for insolvency. There is a definition of insolvency under clause 6.1, and that notice can be served at any time from the employer. It doesn't require the contract administrator to issue a notice and then to wait 7 days before the employer comes along and decides it wants to actually terminate on the grounds of insolvency. And clause 6.7 are the consequences of that termination. Termination and default by the employer. This is under clause 6.8. 6.81 gives 3 grounds. The first ground is where the employer fails to make payments by the final date for payments. The second is where the employer interferes or obstructs the issue of any certificate. And this is where it comes, where I've actually said previously about naming the individual or an individual as the contract administrator, and whether or not that individual is going to be in-house or an external consultant. Because one of the things about external consultants is they are, as opposed to a contract administrator who's in-house, external consultant is looked on with as if he or she is slightly more independent than an in-house contract administrator. So if a contract administrator that's being used is a consultant, the reason why you can't change from an external consultant to an in-house contract administrator is one of the things about there's a question mark over whether or not that in-house contract administrator is independent. But it doesn't matter if the contract administrator is named from the outset, because the contractor would have, by signing the contract or entering the contract, would have deemed that it has agreed to the contract administrator being an in-house appointment. And the third ground is the failure to comply with CDM, exactly the same in relation to a default by the contractor. Clause 6.8.2 are where the works are suspended in excess of 1 month, but it must be before PC. It must be for any reason of a contract, of the contract administrator's instructions under clause 3.6. That's where the contract administrator issues an instruction to say we're suspending works, and then the works are suspended for in excess of 1 month. And the third ground is any impediments, prevention, or default, whether by an act or omission by the employer, is also a reason for or ground for the contractor to actually terminate. Clause 6.8.3 is where if the contractor is going to terminate, then it must serve a further notice, and that further notice will then terminate. And clause 6.9 is very similar to the same grounds as the employer has, and that's for the insolvency of the employer. There is also clause 6.10, which either party may terminate for these reasons. You've got force majeure, negligence of a statutory undertaker, loss or damage to the works and risk is covered by the works insurance policy, and civil commotion and terrorism. Clause 6.11, the consequence of termination under clauses 6.8 to 6.10. And section 7, settlement of disputes. There are three there are three ways that you can set, or that's actually named under the Minor Works, to settle disputes. This is all under section 7. Clause 7.1 is mediation. Now, this is not mandatory. It does say that that clause does say that that the parties should use their best endeavours, or words similar, to actually mediate any disputes, but that doesn't affect a party's right to refer the dispute or the difference to adjudication under clause 7.2. And I've said that that is a default position. It's a default position purely because it is a statutory default position insofar that the Housing Grants Construction Regeneration Act, as amended, gives that right to any party to a contract, to a construction contract, the right to refer any dispute or difference to adjudication. and the vast majority of disputes in the UK is via adjudication. Arbitration, that's also under clause 7.3, but it must be stated within the contract that Article 7 and Schedule 1 applies. If it's not stated, then arbitration does not apply. I've also put litigation there as well, simply because if arbitration doesn't apply, and that the party or one of the parties, they can go off and issue proceedings via litigation. They can do that either without no reference to adjudication, or it can also be done after an adjudication has been done and you've got an adjudicated decision. That will not stop one of the parties from deciding to actually litigate the actual dispute as well. Although saying that, what needs to be done if before the claim form is actually issued and served is that you go through what you call the pre-action protocol periods, which construction has got its own protocol under the civil procedure rules, and what that does is it sets out how the parties should attempt to actually, it's essentially airing the differences via a position statement, via a letter of claim, via a response, and trying to get the parties together either around a table or mediation, and to see if the matter can be resolved without resorting to litigation, or at least see if some of the issues can be narrowed. The pre-action protocol, again from experience, is very, very effective. And that is the end of my presentation on the JCT Minor Works. I have gone through it at quite a faster pace. There is a lot more to actually look at, but if anybody's got any questions, please email them to Jordan. And if anybody wants a copy of any of my diagrams or tables, or even on the presentation, please email to Jordan, and I'll be only too pleased to actually issue that via Jordan. So I thank you, and over to Jordan again.
Thank you, Michael. So bear with me 2 seconds. I'm just going to bring my slides back. There we go. So just quickly, technology is being a bit of a nuisance this morning, and I can't actually open the questions tab. So what I'm going to have to do is pull them all from the system and email them over to you separately, Michael. And then hopefully we can get a little Q&A flyer or Word document or something out to everyone who has attended this morning.
Yeah, that'll be fine.
Yeah, is that okay?
Yes.
Sorry for everyone who has sent in questions already. I don't know why it's not working, but I will try and make sure that it is rectified for the next time. So just a couple of quick things while I've still got everyone on. If you haven't seen it already, our Built Environment Awards for 2021 are now open for nominations. So please have a look on our website. We have a new category this year as well, which is digital transformation. Deadline isn't until the 31st of May, but if you have any questions or you want to submit, then my email address is on the screen right now. So please do get in touch, and I will do everything I can to help and support your submission. And obviously the awards are usually announced during the gala dinner at our annual conference, which we are hoping will obviously be going ahead face-to-face this year in Milton Keynes at the MK Dons Stadium. It is hopefully going to be run as a hybrid event, so there will be the option of attending online if you aren't yet comfortable travelling, or another lockdown is put in place, etc., then hopefully we'll be able to move it all online. So I just really want to say thank you to everyone for logging on this morning, and thank you to Michael for providing another webinar for us. Hopefully we will actually get you at a conference in the future. Obviously that's where we were originally supposed to hear you talk, so it's great that you've been able to support us in our webinars instead. As we've already said, if you have any other questions or comments, feedback, etc., please do send them through to either directly to myself or to the webinars inbox, which I pick up as well. Our next webinar is on the 17th of March at same time, so 10 AM. It's with our head of membership, Ian McLaughlin. He's going to be giving everyone an update on the process of applying for membership with the Engineering Council. We have quite a bit of an update for everyone, so if you're interested in learning more, then you can book for that via the website now. But again, thank you very much. Thank you again to Michael. Hopefully I'll see you all online again next month, and I will get this webinar up onto our YouTube channel as soon as possible. Thank you.
Thank you.